Hello and welcome to the latest in our BedBiz podcast series brought to you by the National Bed Federation. It's all about talking to our industry partners and bringing you interesting insights which we hope will help you within your businesses. And today I'm very pleased to welcome Macdonald, who is the CEO of Anti-Copying in Design. We're taking a little bit of a different approach to our podcast today, insofar as Macdonald is going to give us a little bit of a webinar all about what anti-copying in design does. So without further ado, Dids, welcome, hello.
Hi, Jess.
Hi. I'm going to hand over to Dids, who's going to start sharing her screen with some slides. So Dids, over to you.
Excellent, excellent. Well, hello everybody, and thank you, Jess, for the opportunity of telling you a little bit more about anti-copying in design. And we're delighted to work very closely with the National Bed Federation. And it's really good to be doing these webinar series, although I think this is a slight stray from the normal of your podcast. So intellectual property is quite a difficult subject. So I always believe in pretty pictures to actually sort of try and tell you a little bit more. So first of all, what is ACID and what are our main objectives? Well, ACID, I'm the CEO of ACID and I'm also the co-founder. And the reason I started ACID was because when I was a designer, every time we brought out new products, they were copied. So I got very angry. And along with a few like-minded people from Chelsea Harbour, where we had a showroom, we started a 2-year journey to try and do something about it. So here we are about 2 decades later, and I think it's true to say that we're the go-to organisation for government. And our objectives and aims remain the same as they did when we first started, which is education and awareness. And that's learning about IP, really to put the practical aspects of any business. That's designers, manufacturers, and those who rely on copyright and patents. So it's about education and awareness, prevention against copying, deterrence against copying, and also supporting our members. We believe in about the success stories of our members. That's about new launches, new products. So it's really about looking at ACID as a positive force for growth. And we're also a campaigning body and shout very loudly to government. One of our main achievements was changing the law in 2014, and that made the intentional infringement, I can't get my words around that, the intentional infringement of a registered design a crime. And that's really important to us and obviously to designers and manufacturers. There is a lot of confusion about intellectual property, and I look at it in a very simple way, which is I look at the analogy of a house or a home. So intellectual property is a property right, as it says here. And just as the same as you could do for your home or flat, you can lease it, sell it, sublet it, rent it, or share it. You don't want squatting. So intellectual property, very simply, is about ownership and permission to use your property. Let's go on and discuss intellectual capital. What is intellectual capital? Well, it's a critical aspect. It's the DNA running through most creative businesses, whether micro or macro. And this is particularly true for furniture makers and manufacturers and those in the bed sector. What do I mean by intellectual capital? Well, it's about the relationships you have under your brand. It's your expertise. It's your know-how, it's your people capital, those with whom you work. It's about your suppliers, your customers, your technical know-how. So everything about your company sits on is your intellectual capital. And intellectual property is really a key part of that. Let's look at Hypnos as a good example. Hypnos have got so much of what I've just described sitting under their brand. They've got the credentials of Queen's Awards. They've got their very, very important brand. And underneath their brand sits quite a few trademarks. They've trademarked, for example, Hypnos, the most comfortable beds in the world. They've trademarked Hideaway. They've trademarked Comfort with Integrity and Hygeia. I think that's the correct way of pronounce it. So when I talk about intellectual capital, and you think of many of the successful bedding companies in this country, or bed manufacturers, Hypnos, Silent Night, Harrison Spinks, all the major brands that we know, there's huge capital and sitting underneath them. So I'm often asked, well, does ACID only represent the interests of designers? Well, no. We've got many manufacturers who are members, because obviously they rely on trademarks, copyright, and also to a lesser degree patents. Patents are about inventions and the way something works. So it might be that you have a particular spring that in a mattress that has a patent. Therefore, that is part of your intellectual property rights. So it's really all those within the creative industries, designers, manufacturers, designer makers, that we represent and have done for many years. In terms of benefits, we've got what's called an IP data bank, and I think the National Bed Federation have a similar thing for trademarks. And the IP data bank is simply, it's almost free, it costs pence to upload all your designs, whether you're employing freelance designers or you have your own design team within your manufacturing remit. And it means that you've got the designs, unregistered designs, held there on our safe IP data bank. I guess we have about 300,000 of them. So this is a very good resource. It's third-party evidence of when they're sent to us. You get a certificate. It's a tamper-proof certificate, numbered certificate, also supported by the Police Intellectual Property Crime Unit and signed by our ACID Chief Counsel, Nick Kanupius. So it's somebody else holding evidence of your IP should you ever need it. ACID Marketplace is just what it says. It's an opportunity to another alternative opportunity to showcase your new designs, products, etc. For our corporate members, we have intellectual property reviews, strategy reviews, and that's looking at your company. We'll come and visit you or do now what we've been doing, as everybody does on Zoom. We send a questionnaire, we ask you some questions. By and large, very few people have actually taken the trouble to look at their intellectual property in depth. It's really important to do this because it can be an asset in the sale of a property. Also, there are various tax incentives, etc. So what we would then come back with is a step-by-step guide to really put a proactive stance into your intellectual property strategy, all the way from the seed of an idea to marketplace and all the various stages in between. Members benefit from discounted legal fees and initial free advice. We're supported by 5 of probably the best UK intellectual property lawyers who've got specialists in trademarks, patent registrations, specialists in certainly the furniture industry and bedding industry, because they've worked with us at grassroots, at the exhibition, so they know what your issues are. And a member-to-member discount, so if you are a member, you can offer your products to our members at a discounted rate. I've talked about the ACID Design data bank marketplace. Brand enforcement is a very key aspect of our offer, and that couldn't be more important in the value of trademarks, which is really the brand which really distinguishes you from others. And I cannot emphasize how important it is for all designers, all manufacturers, indeed any owners of intellectual property, to think about their brand protection. That's a quick eyeball at the logo for that. So what sort of things should a manufacturer employing a designer do or not do? That's one of the very frequent questions that were asked. So if you're employing a designer, ensure that you've got the right sort of agreements with them, because a change in the law in 2014 meant that the obviously people think are under the wrong impression that the commissioner owns the designs. They don't. If you're employing a freelance designer, always have an agreement in place to clarify that ownership. And if you want the IP rights assigned, then that is a separate agreement. Again, we have generic agreements that put in your standard terms and conditions of business. If you have a design team or you employ a designer, then as probably you all know, the employer owns the IP rights. A word of caution there that obviously employees do go from place to place, and the most important thing is to have that agreement in place about the protection of your IP should an employee leave to go to another country, and that's all about trade secrets. When you think about trade secrets, it's your customer lists, it's the origins of your designs, it's all the things that are under this intellectual property umbrella. Ensure you've got an IP policy or a statement in the terms and conditions of employment. I've talked about freelancers ensuring that IP agreements are in place to ensure IP rights ownership. And also, really important, don't ask a designer to copy or alter another's designs. People really are onto the case, and obviously if you do ask a designer to alter something to suit what you want to create, that could land you in an awful lot of trouble because you are potentially infringing somebody's intellectual property rights. So I always say that if you don't pay attention to the small print, it makes lawyers rich. And so I can't emphasize more. It's very easy to do, and it's very simple with help from us or help from your IP lawyer to get those IP parts of your terms and conditions of business and your terms and conditions of employment in place. So I've talked about brands, and the most important thing to brands are trademarks. Well, one of the most, obviously, your designs and your patents and your copyright. And what's in a name? Well, a lot, as I've just shown with the example of Hypnos and other major brands that we're aware of in the UK, especially in the bedding sector. Why should you register a trademark? Well, obviously, if you've got a piece of paper saying that you own that trademark, this is a very valuable asset. And a trademark lasts as long as you wish to use it and as long as it's renewed. It's what's called a unitary right. Why is trademark protection so important? Well, it's important to look at what you can actually trademark. And we saw in the earlier example, you can trademark your name as a logo. You can trademark certain phrases that go with possibly a new product launch. And so that's one way of protecting a new range that you may wish to launch. It's also interesting to look at territories and thinking, well, if I'm dealing in different territories, we all hope that with the new trade agreements, or new trade agreements will be reached with different countries where the government will be promoting our sector, we hope. And so it's important to look at your territories. When looking at territories, there's a great asset that the Intellectual Property Office have started, which is called IP attaches. And they're based in all the embassies in various countries like India, China, United States, Southeast Asia. There are about 7 of them, and they're really useful contacts. So anybody wanting to know about it, they'll look at the Intellectual Property Office or with a section on our website. A lot of people rely on unregistered trademarks. Unregistered trademarks arise automatically. So that if I put my name as Diz Macdonald and start trading under my name, Diz Macdonald, I automatically have unregistered rights in my name. So that's building up, over the years, I guess I've built up a certain intellectual capital under my name. If I chose to register Diz Macdonald, I probably could. I haven't done that. But it's just that I think the most important thing is that a lot of designer makers don't register their rights. They have unregistered rights under their name. Anybody who has unregistered rights can put the little TM beside their trademark. And anybody who has registered rights can put R in a little circle. Why would I do that? Well, I think it's important at every opportunity to send the message that you know about your IP rights. So putting R in a circle means that you've thought about your IP rights, you've registered the trademarks, you've maybe registered different aspects, or in various names and product launches. So let's move on to design. A lot of people ask, well, what is protected by design right? And I've used an example here, which is Jan Waterston, who's produced this wonderful, I think it's really a side table. And I think that's a really good example of what's protected. In simple terms, it covers the contours. In this, you can see the contours of this design. That can be protected. Lines can be protected. The materials that they're made of can be protected. The shape. If you look at the shape of this, obviously there's a shape, and that shape can be protected. The ornamentation, what do I mean by that? Well, that's what you put on the surface area of a design. The texture, it may be that your design has a certain texture in it, and also the colour can be protected. So all those 7 criteria, one or all of them, can be used to protect your design. There are 2 types of design right. Registered on one hand, that's an official registration where you've got a piece of paper, a certificate, which says that you own that design. As long as you renew it every 5 years, you've got a very valuable asset. If you're relying on unregistered rights, then you've got those arise automatically, a bit like the trademark or unregistered trademarks I mentioned. And those are protected from anything from 3 to 15 years. A lot of people say, in fact, let me just reel back a minute. The majority of UK designers rely on unregistered design rights. And that's where our IP data bank comes in very handy, because it's a way of just sending them so that a third party has evidence of that creation of your unregistered design. At all points, ASID would say, register your designs officially, because it gives you that fantastic armory, IP armory of things that you probably spent an awful lot of time and money designing, doing the prototypes, R&D, bringing to market, etc. So this gives you that, this is part of what I call your IP strategy. Simple, fairly cost-effective steps that you can take to make a difference to your brand, your overall intellectual capital. A lot of people say, well, what's the difference between a design protection and a patent? Well, before I go on to that, I'll just give you this rather ornate example of a question that was given to us, saying, well, mattresses and beds are surely difficult to protect because they're so similar. Well, this is going from one extreme to the other, but it just shows that this is an example of the design of something that could be protected, because you've got all those elements that make it distinctive. You've got the, the tree and the little nest in the middle. Obviously, this is going to one extreme, but if the bottom line is, if you've got a bed design that has a different shape, that maybe using a different shape in the headboard, maybe on the mattress cover you're using different surface decoration, or again that all important distinctive feature. Those are all the things that can be protected by design right. A patent, on the other hand, protects the invention of something. It's an invention, it's actually how it works. So if you think of the company Amic, they've got a patent on the unique way that they're, I don't think you could call it a mattress set. What would you call it, Jess? I can't think what it's called, but it's a series of molded forms that move into the contour of the bed, and they've patented that. So that's where patents come in terms of certainly the bed sector. And I mentioned earlier about it may be a mechanism or spring or something within a manufacturing basis that can be an invention or the way something works. So the bottom line is it confers a registered protection on any new idea, invention or process. So if we take Dyson as example, he relies on patents. He relies on patents 20 in the ratio 24:1 on a worldwide basis, and they have, I think, they employ lawyers on a worldwide basis because they are copied so much. Patents are obviously probably the strongest IP protection. They last for 20 years. It does take a long time to get a patent. The most important thing about a patent is to remember not to exhibit it or share the idea with anybody else until you've got in touch with an IP lawyer and they can advise you on the process. And that usually includes the advice patent applied for. I'm just going to go back to the whole aspect or the whole thing about IP. And I use the analogy of a smartphone. And if you think about a smartphone that we all use, it encompasses so many intellectual property rights. So for a starter, in the smartphone, you've got trademarks in the name of whether it's an Apple or a Samsung. You've got trademarks in the name of the manufacturer. You've got patent and utility models in the way that it works. You've got copyright in the software, user manuals, ringtones, startup tones, images. And also there are the trade secrets under any brand about, for example, Apple or Samsung, that really make part of the intellectual capital of that country. And obviously the design is the look and the feel of that smartphone. So I think that just gives a broad picture of how intellectual property rights really cover most things that certainly within the bedding industry and all industries within the creative industries, there is some element of intellectual property. Go on to Brexit in a second, but if you think of copyright, which I haven't really touched upon, copyright is a very important aspect, for example, in your technical specifications. So if you think of your website and the technical specifications that you might publish, this is all your intellectual property. If you think of that as a real value that you must have taken quite a lot of time getting together. If you think of your website, your marketing material, all the images that are on your website, and it's most important to think about images. You're working with a photographer, make sure that they sign the rights to if you're going to use them and want to continue to use them or get some sort of agreement. Obviously, if you take your own photography in-house, then you own the copyright in those photos. So copyright is a consistent theme running through most brands. Let's go on to Brexit, and one of the what we consider one of the most calamitous aspects from an intellectual property point of view is that both the EU and the UK turned its back on unregistered design protection. Before, up until the 31st of December this year, any designer could automatically rely on unregistered rights in the European Union's 27 member countries, as well as the UK. I showed the photograph, the slide earlier of all the elements which make up a design. So UK designers are at a disadvantage. What the UK government have done is provided a supplementary right, which will cover all those aspects. But what it doesn't do is give automatic protection in EU 27. What are we trying to do about it? Well, we're going to try and, we have for the last 4 years, trying to get clarity from government so that there is simultaneous publication. What does that mean? Well, say if you're a bed manufacturer bringing out a new design and you're relying on unregistered design rights in the UK, and you show it, for example, at the show in September for the first time. If you're then going over onto a European exhibition and you show that design, it will not be protected. What we're asking government to do is to provide clarity. We'll be working with the EU and also the UK on that. But this is a really important issue, which I hope we'll be working with the NBF to hopefully promote that issue as a priority within the British Furniture Confederation. So that really is a whistle-stop through IP from me. I'm delighted to be working with Jess and the team at the NBF. We offer, obviously we work closely together, so any particular queries can be sent through Jess to us. We offer NBF members not a reduction, that take away the joining fee if you do become members of ACID. And it's now my pleasure to hand over to Jess to see if she's got any further questions which I haven't really covered. Thank you.
Thanks, Jid. I've just paused because I can't get my I seem to have lost my view here. So, that's it. Right. Okay. So, that's it. I will start again. Did, thank you so much for that. That was really interesting overview of all the amazing things ACID has done since you founded it. I'm sure you didn't expect this kind of journey when you first got passionate enough about setting up such an organization, but I'm sure that many people in the industry have been very grateful for ACID's support and advice over the years. I've got one little question for you just to finish off. You talked quite a lot about registering designs as trademarks. Is that, obviously, you know, particularly amongst bed manufacturers, they're quite frequently introducing new products and tweaking them and maybe have quite a wide portfolio of products for different customers, etc. Is it expensive to register a single product?
Well, I think what I need to do is wind back, because you can't trademark a design. You can register a design. It's called, that's design rights. I talked about unregistered design rights and design rights. So any new products, if they fulfill that criteria, can be registered, and you register them with the Intellectual Property Office. It costs about £60 for the registration. That's for one registration. If there are a range, it goes down pro rata. The advice I would give is to always get somebody. What you register basically is what you rely on. So if you think about, I don't know if you all remember the Trunky case, but the Trunky case failed because what they registered, they couldn't rely on at the end of the day in the Supreme Court. And I should know because I was there when I saw lots of the Trunkies around the place. So that's the word of caution. A registered right is a monopoly right. That means that basically, if I, for example, designed my Samsung and registered it, I would own that if nobody else had done it, obviously. So basically it's a piece of paper which says that you own that design. A trademark is different because you're registering the name of something or the name of a product range. So that's the clear distinction. So putting the umbrella term of intellectual property rights, it's copyright, trademarks, design right, and patents.
Thank you for explaining that. I can see why you said it was quite a complicated scenario.
Well, very few people, not very few, but in the IP world, design right is called the Cinderella right. And it's called the Cinderella right because it rarely comes to the party, but it's a very important right because we've got 1.69 million people in the UK involved in design and design skills, and design skills GVA to the UK government, economic picture is £85.2 billion. So if you think of all the design, I mean, design is all around us. It's iconic, from every day. It, it provides solutions. If you design something better, it's providing a solution. It, it's part of our everyday. I look around this, this office here, and I can see everything is designed to a lesser or greater extent. So design is very, very important, and design right is very important. Just to recap, unregistered designs arise automatically. So you've got automatic protection when you design something. That's where the ACID IP data bank comes in. And registered design means that you pay a sum to the Intellectual Property Office, you get a certificate, it says you own your design.
Okay, yeah, well, thank you for, yes, I can see that obviously that ACID offers some really useful services for such as the data bank, which would be fantastic for these unregistered designs, which I suspect is what most manufacturers have, unless it's,
Well, we have about 25,000 of those a year, which are lodged with us. So it's a very important benefit because it's got that all important evidence.
Yeah. And we, of course, have our own, for our own members, our trade name register, which is both registered trademarks, but also for product names and product ranges which possibly aren't registered, but which at least members can look up and see, has anyone else called their model a princess or a regency?
Yeah.
Something. So it's quite useful from that point of view. So, but also the fact that you provide access to legal advice or help with drawing up contracts and all those kinds of things are really, really useful. So thank you for joining us today, Dids. It's been, I know it's been a whistle-top tour, and you've really only had an opportunity to just scratch the surface, I suppose, but I hope this encourages more people to be more aware of this fantastic service you offer.
Thank you.
To help people navigate through what is such an important part of their business, their intellectual property. And obviously members of ours and everyone else in the industry can access more information both through our website and through the ACID website. So once again, Dids, thank you very much indeed.
A pleasure, Jess, and thank you very much, and all good luck with your show in September.
Thank you.